Welcome to our channel, Law Road. Contract law at your fingertips. Today, we are discussing acceptance in contract law. Acceptance means an assent to an offer made by a person to whom the offer is made. The definition is in reference to Section 1 of the Contracts Act, Chapter 284, Laws of Uganda. To make a binding contract, the acceptance must exactly match the offer. That is, the offeree must accept all the terms of the offer. However, it's possible to have a binding contract without a matching offer and acceptance. In Broden versus Metropolitan Railway, the complainants, Broden, were suppliers of coal to the defendant, Metropolitan Railway. They completed business dealings regarding the coal frequently for a number of years on an informal basis. There was no written contract between the complainant and the defendant. When a dispute arose, the issue in this case was whether there was a contract between Broden and the Metropolitan Railway, and if the written agreement they had was valid. The House of Lords held that there was a valid contract between suppliers, Broden, and the Metropolitan Railway. The draft contract that was amended constituted a counter-offer, which was accepted by the conduct of the parties. The prices agreed in the draft contract were paid, and coal was delivered. Although there had been no communication of acceptance, performing the contract without any objections was enough. Note that court has developed rules in regard to acceptance, and one of the rules is counter-offer. If in reply to an offer, the offeree introduces a new term or varies the terms of the offer, then that reply cannot amount to an acceptance. Instead, the reply is treated as a counter-offer, which the original offerer is free to accept or reject. In summary, a counter-offer is a rejection of the original offer which cannot subsequently be accepted. In Hyde versus Rake, the defendant Mr. Rake offered to sell the farm he owned to the complainant Mr. Hyde. He offered to sell the property for £1,200, but this was declined by Mr. Hyde. The defendant decided to write to the complainant with another offer, this time to sell the farm to him for £1,000. He made it clear that this would be his final offer regarding the property. In response, Mr. Hyde offered £950 for the farm in his letter. This was refused by Mr. Rake, and he confirmed this with the complainant. Mr. Hyde then agreed to buy the farm for £1,000, which was the sum that had previously been offered. However, Mr. Rake refused to sell his farm. The complainant brought an action for specific performance, claiming that as Mr. Rake refused to sell the farm, this was a breach of contract. The issue in this case was whether there was a valid contract between the parties and if a counter offer was made in discussions, whether the original offer would still remain open. The court dismissed the claims and held that there was no binding contract for the farm between Mr. Hyde and Mr. Reg. It was stated that when a counter offer is made, this supersedes and destroys the original offer. This original offer is no longer available or on the table. In this case, when Mr. Hyde offered £950, he cancelled the £1,000 offer and could not backtrack and accept. Note that a counter offer is different from a mere request for information. A case study in reference is Stevenson versus Micklin. The second rule that courts have made is tenders. A tender is an offer, the acceptance of which leads to the formation of a contract. In our example 1, where X advertises for offers to supply a specific quantity of goods to be supplied during a specified time, and Y offers to supply, acceptance of Y's tender creates a contract under which Y is bound to supply the goods and the buyer X is bound to accept them and pay for them. The second example is where X advertises for offers to supply goods up to a stated maximum during a certain period, the goods to be supplied as and when demanded. Acceptance by X of a tender received from Y does not create a contract. Instead, X's acceptance converts Y's tender into a standing offer to supply the goods up to the stated maximum at the stated price as and when requested to do so by X. The standing offer is accepted each time X places an order, so that there are a series of separate contracts for the supply of goods. A case study in reference is Northern Railway Company versus Witham. The third rule that courts have made is communication of acceptance. The general rule is that an acceptance must be communicated to the offerer. In Section 2, Subsection 2 of the Contracts Act, Chapter 284, the communication of acceptance of an offer is made by an act or omission of a party who accepts the offer, by which that party intends to communicate the acceptance, or which has the effect of communicating the acceptance. No contract comes into existence unless the acceptance is communicated. That is in reference to Lord Dining in Entowers versus Miles Far East Corporations. The acceptance must be communicated by the offeree or someone authorized by the offeree. That is in reference to Powell versus Lee. The offerer cannot impose a contract on the offeree against his wishes by deeming that silence should amount to an acceptance. In Feldhaus versus Bindley, the complainant Paul Feldhaus had a conversation with his nephew John Feldhaus about buying his horse. After their discussion, the uncle replied by letter stating that if he didn't hear any more from his nephew concerning the horse, he would consider acceptance of the order done and he would own the horse. His nephew did not reply to this letter and was busy at auctions. The defendant, Mr. Bindley, ran the auctions and the nephew advised him not to sell the horse. However, by accident, he ended up selling the horse to someone else. Mr. Bindley argued there was no valid contract for the horse since the nephew had not communicated his acceptance of the complainant's offer. The issue in this case was whether silence or a failure to reject an offer amount to acceptance. It was held that there was no contract for the horse between the complainant and his nephew. There had not been a contract. There had not been an acceptance of the offer. Silence did not amount to acceptance, and an obligation cannot be imposed by another. Any acceptance of an offer must be communicated clearly. Although the nephew had intended to sell the horse to the complainant and showed his interest, there was no contract for sale. Thus, the nephew's failure to respond to the complainant did not amount to an acceptance of his offer. Where an instantaneous method of communication is used, for example, when telext is used, it will take effect when and where it is received. A case study in reference is Bain and Company versus Leon van Tienhoven and Company, where postal rule is restricted only to the reply of an offer. Thank you for watching. Don't forget to subscribe to our channel, Law Road, giving you contract law on your fingertips.